arbitration offers a way to resolve disputes outside the crowded court system. Instead of waiting years for a court verdict, parties can choose a neutral arbitrator to decide their case. The arbitrator's decision, called an arbitral award, is legally binding. Arbitration is popular because it promises speed, efficiency, and expertise. Parties can even pick an arbitrator with specialized knowledge. The process is less formal, with relaxed rules and more control over scheduling. But sometimes, a party is unhappy with the award and believes there was a serious error or unfairness. The law allows limited challenges to arbitral awards in court, but only for specific serious flaws. Courts don't rehear the whole case. They act as a safety net to ensure fairness. In India, the Arbitration and Conciliation Act, 1996, governs this process. The Act's goal is to make arbitration attractive by minimizing court interference. Courts are not meant to act as appeals courts, second-guessing the arbitrator's judgment. They only step in for significant errors that threaten the integrity of the process. This balance is crucial. It keeps arbitration fast but fair. The Act also sets out strict rules for how and when awards can be challenged. The system is designed to resolve disputes quickly, so parties can move on. But the process doesn't always end with the arbitrator's award. Sometimes, the losing party tries to delay enforcement by challenging the award in court. The law tries to prevent endless delays, but loopholes and excuses can slow things down. That's why courts are increasingly strict about enforcing deadlines and limiting challenges. The Delhi High Court's recent decision is a strong example of this approach. If a party is unhappy with an arbitral award, they can't just appeal like in regular court cases. Their first step is to ask the court to set aside the award under Section 34 of the Arbitration Act, but only for narrow reasons, like bias or lack of a fair hearing. The court reviews only these specific complaints, not the merits of the case. If the court rejects the challenge, the losing party can file a further appeal under Section 37. This Section 37 appeal is the final chance to contest the court's decision on the award. But there's a strict deadline. Usually, the appeal must be filed within 90 days of the court's order. This deadline is crucial to keep the process moving and prevent endless delays. If a party misses the deadline, they can ask the court to condone the delay, but only if they show a sufficient cause. The court has discretion to accept or reject the excuse for being late. Routine excuses aren't enough. The reason must be genuine and compelling. The law's intent is clear. Arbitration should be quick and delays should be rare. Endless appeals and late filings defeat the purpose of arbitration. The Delhi High Court's recent judgment focused on what counts as a sufficient cause for delay. The court's approach signals a tougher stance on excuses. Only serious, unavoidable reasons will be accepted. This ensures that arbitration remains a fast and effective way to resolve disputes. The message: deadlines matter and parties must act promptly. Common excuses for missing deadlines include slow file movement within organizations and changing lawyers. Government bodies and big companies often blame internal bureaucracy or the time needed for a new lawyer to get up to speed. These reasons sound plausible, but they're used so often that courts have grown skeptical. Such excuses can mask carelessness or deliberate delay. The real question: when is a delay truly unavoidable, and when is it just a convenient excuse? The Delhi High Court made it clear: routine excuses like file movement or changing counsel are not sufficient cause for delay. The Arbitration Act demands speed, and internal inefficiency is not a valid reason to miss deadlines. Litigants must organize their affairs to meet legal timelines. Changing lawyers is a right, but it can't justify leisurely delays. The court expects parties, especially large organizations, to be diligent and proactive. Delays will only be excused in truly exceptional cases, not for everyday administrative hurdles. The message: respect the finality of arbitration and don't expect sympathy for routine delays. The bar for condoning delay is now much higher. Imagine a small contractor wins an arbitration award, but the losing company delays payment by blaming slow file movement or a change of lawyers. These delays hurt the contractor, who needs the money to pay employees and suppliers. If courts accept such excuses, big companies can use inefficiency as a weapon to stall justice. The Delhi High Court's decision prevents this unfairness. Managing legal representation and meeting deadlines is the litigant's responsibility. Changing lawyers should be done efficiently, not used as an excuse for delay. The judgment protects the winning party from endless waiting. It keeps the arbitration process fair and effective. The Delhi High Court's judgment is about more than just two excuses. It's about protecting the integrity of arbitration. Arbitration's main advantage is speed. Endless delays destroy that benefit. The ruling forces parties to streamline their processes and respect deadlines. For winners, it means faster access to justice and certainty. For businesses, it brings predictability and encourages investment. The court's message, justice delayed, is justice denied. Timelines are not suggestions. They're essential for real justice. By holding parties accountable, the court strengthens the entire system. Arbitration remains a true alternative to slow litigation. The judgment is a wake-up call: act promptly or risk losing your chance in court.